Hi, my name is Eileen Mostricht, and today I wanted to talk about the advance directive called the Designation of Healthcare Surrogate. This is what we call in Florida the document in which you name somebody to make healthcare decisions for you if you are unable to do so yourself. Like if you can't communicate, you're incapacitated, maybe you've had a stroke, Alzheimer's, you're not conscious at the moment, whatever the case is, it's important that we name somebody to make those decisions for us. Now, importantly, in Florida, if you never get around to doing this document, we do have a statute that is commonly referred to as a proxy statute, that sets out an order of in order hierarchy of people that they will allow to make decisions for you if you have never done this document. For example, if you're married, the first in priority is going to be your spouse. If you don't have a spouse, then your adult children. If you don't have adult kids, then your parents. If you don't have parents, then your siblings. So it goes in that order. So at least there we have that backup if you never do that document. However, it can sometimes prolong things a little bit and cause conflict because let's say you don't have a spouse and now it's your adult children that are making this decision and you have more than one adult child and they don't agree. So if they're fighting, because there's nobody of the adult children that has priority over the other one, if they're fighting, then it's going to hold things up and the hospital administration is going to tell you to work it out or go to court or do whatever that needs to be done. But what if there's an emergency and something has to be, sometimes decisions do need to get made need to get made quickly. So the absolute best thing to do is to do this document and not have to rely on that proxy statute. You get to choose who you want to make that decision. Now, this is the one document, the one that if you are a diehard do-it-yourself person, I love to DIY things too and kind of tinker around, so I completely understand that. If you are dead set on doing something on your own in this whole estate planning set of documents, this is the one document that I say, okay, it's all right to go do this on your own. It's pretty standard what's required to be in this document. You can really get this document even from a hospital. They will gladly hand you this document because they really want you to have it. And you just fill it out and it needs to be witnessed and signed. And then you have that document. Any estate planning attorney is going to include this document in the package of all of the estate planning documents that you get. But if you just are insisting you want to do something on your own, this is one that you could do. Now, who should you name? Should you name a single person, one person or co-agents? Ideally, you should name one person at a time. I mean, you can have, if that person's not available, then the next and the next. But ideally, it should be one person at a time. I'm an RN as well, and I have seen firsthand how this plays out. And it's usually the charge nurse that needs to track down this person. And sometimes, charge nurses are so busy. And if they have to hunt down two people, and then they have to make sure that those two people agree, it can be really difficult and slow things down. So I highly recommend one person, and you can explain this to your children, that nobody's being left out here. We just need to have a point person. The children are all going to confer anyway, but there needs to be a point person. Now, I do have some people who insist they cannot just name one of their kids, and they insist on having co-agents. And if that's the case, then I will put that, but then I will add on to there that says either of whom may act alone in an emergency. If there's an emergency and decisions have to be made and the charge nurse can only get a hold of one person, then that person is going to get to make that decision. It's important. You don't want your healthcare to be delayed. All right, so that's the designation of healthcare surrogate. In other states, it is sometimes referred to as the medical power of attorney. It's the same thing. In Florida, we just call it the designation of healthcare surrogate.